Okay, very good evening, everybody. Welcome to this Licensing Subcommittee C meeting. My name is Gareth Sykes. I am the Governance Services Officer for this meeting. I'm going to very briefly read out the protocols for the remote meetings before we then start the formal agenda. Okay, in terms of the protocol, only speak when invited to by the chair. If you wish to speak, please raise your hand and direct all communication via the chair. Will everyone please ensure that their mics are muted when they are not speaking, apart from the chair, who does not need to mute their mic at any stage. When speaking, please be succinct and do not exceed the allotted timeframes highlighted at the start of the hearing. If you are referring to a specific page or picture and report, refer to that page number. If you're having any technical difficulties, please use the chat function in Google Meet to alert the meeting or dial in via the phone number. Please do not use the chat function to put any formal questions to the licensing subcommittee. Any persistent disruptive behavior will result in removal from the meeting. Well, this next one is we have more than one application, but for this evening there is only one application, so that does not apply. Applicants and all of the parties will be asked to leave the proceedings once the meeting has concluded. Once all the applications have been considered, any remaining parties will be asked to log out. So that concludes the remote meeting protocol. So we will now go to the formal meeting agenda. And we'll begin with nominating and electing a committee chair, please.
I'd like to propose Councillor Peters, if I may.
Thank you. In which case, well, I'm happy to accept that nomination. The order of business, as everyone should see, is on the, I think, which is effectively the third page of the agenda pack. First item, as we've just heard, is the election of a chair. Then we have apologies for absence.
What apologies from Councillor Bell, Chair?
Thank you very much. There is an item on declarations of interest from members of the panel. Do we have any? No, wonderful. And then the fourth item is to just alert everyone's attention to the licensing subcommittee hearing procedure, which is type C, which you'll find in the pack. I'm just working from an electronic copy, so I can't give people page numbers, I'm afraid, but this procedure is for the review of a premises license or indeed a club premises certificate. And on that, you'll see that we have a number of steps. As we've heard, we only have one application this evening, and that is for the review of the premises license at Topologlu Food and Wine on Kingsland Road. Step one on the meeting procedure is appointment of chair and introductions. So I propose that we do a tour of the virtual room. My name is James Peters. I'm a councillor in de Beauvoir, and we have Councillor Root here as well.
Yes, my name is Penny Root. I'm the councillor for Victoria.
Okay, Amanda.
Hello, good evening, everyone. My name is Amanda North. I'm a solicitor from Legal Services supporting members this evening. Thank you.
Gareth.
Gareth Sykes, Governance Services Officer. I will be taking the minutes for this evening's licensing subcommittee meeting.
Wonderful. Subhanjina.
Subhash Redamana, Principal Licensing Officer.
Wonderful. We also have Karishma here as well.
Yes, good evening, everyone. I'm Karishma Mohammed, the trainee solicitor, just observing the meeting.
Okay. David.
Hi, David, Team Leader, Licensing and Technical Support.
Sorry, we have two. We have two Davids. Sorry for the confusion. I'll just go around the sort of officers here. PC Hunwick.
Yes, Chair, is PC Hunwick from the licensing unit at Winnow Shoreditch Police Station.
Oh, okay. We also have IT support from Mario here. I don't propose that you need to introduce yourself, but we do have Mr. Dads representing the applicant.
Yes, good evening.
And you're all very welcome. So that's step one. Step 2, we will hear from the licensing officer to outline the report.
Thank you, Chair. Licensing Service received an application from the Metropolitan Police for the review of a premises license under Section 51 of the Licensing Act 2003 for Chocolobu 478 Kingsland Road. Only licensing authority representation remain. The police and the licensee have submitted additional information which has been circulated. I have nothing else to add. Thank you, Chair.
Thank you very much. So, unless Councillor Root has any questions for clarification on what you've just said, I will ask. We'll move to step 3, which is the applicant's case. So, slightly unusually, this is the Metropolitan Police, I understand.
Yes, Chair. Just to summarise, because I believe you, from memory, that you sat in on the original review for this premises. As a brief summary, a serious assault occurred, we believe, caused by members of staff at the venue. That investigation is still ongoing due to various different COVID issues. A determination was made in the subcommittee with regards to a suspension period that should be served. That the DPS should be removed. There were a number of conditions updating the licence that were put onto the licence. We have had a number of concerns in the ensuing period that unauthorised sales were ongoing during what we believe to be the suspension period, and a new independent DPS had not been installed. However, through discussions with myself, Mr. Dads, on behalf of the venue, and the licensing authority, David Chewett, we have come very recently. These talks were still ongoing right up until subcommittee started. We have come to an understanding with regards to the way to move forward, with regards to proposals that have been made, which have been put before the committee. And these are submitted for your consideration.
Thank you very much. So that's the position statement that we received this afternoon, is it?
That's correct. I mean, it effectively removes the licensee from the picture on a permanent basis, which we believe does promote the licensing objectives.
And just to be clear on what we're talking about there, Mr. Sajad Popal would be removed as director of the company. He would also, there's some wording here about being removed as a person with significant control or influence of the company. Does that mean that he would relinquish any shareholding in the company as well? Is that what that means?
That's correct, Chair.
Okay.
Oh, sorry, I'll just come in there. That's just what we found in relation to limited companies, company directorships, and persons who have significant control.
Yeah. Just to further dig into this a little bit more, and I'll let Councillor Root come in a minute if she has any further questions about these this position statement. If Sercan Limited were to, for any reason, sell on the lease of this premises, I assume they have a lease on these premises rather than only the freehold, or it actually doesn't really matter. But in any case, if Sercan were to sell on these premises, then it's envisaged that 2.2 would mean that in any case, Sajad Popal would not be able to have any involvement with any licensable activities on the premises. That's the idea, is it?
Yeah. That's the idea, and obviously there would be objections to any transfer of the premises license if it was there was to be any sort of any attempt to transfer it back to himself in a different legal entity, which was hoping that wording would tighten it up.
Yeah. Okay, now I can see that. Can I just ask about point 3 and 4? So when the subcommittee met last time and looked at the incident that caused it to suspend the license last time, which was, as you say, appeared to be quite a significant and serious incident in which a bunch of young men grabbed hefty sticks and ran outside, and which seemed to result in a man being rushed to hospital with broken ribs. Albeit, I take the point that there hasn't been any conviction as yet, but that is certainly the video evidence that we saw did strongly suggest that. Following that, we did order the removal of Sajjad Popal as the designated premises supervisor, and the suspension of the license for 3 months. But in points 3 and 4 here, you're saying, oh look, you didn't comply with that suspension. Here, have a 1 month suspension instead. I'm not quite understand the logic of that.
Well, I mean, it was on that basis that we've brought this further review of the license, that suspension period didn't occur, and a number of movements occurred with potential DPSs that appeared to be joint suspects in the venture. I'm sure Mr. Dadds will give his view on the suspension. There's been a number of issues raised with regards to the wording of the decision letter as to why that suspension period hasn't occurred. And we would leave that, as I say, this was why we raised this review, and this is why we are still having you hearing it, because obviously you had made a determination previously. But I will leave that to Mr. Dadds to argue that particular point.
Just trying to work out how to do this. Mr. Dadds, maybe I will. Actually, no. Councillor Root, did you have any further questions for PC Hunwick?
Well, I've got one question, because PC Hunwick referred to Sajjad Popal as the licensee. What role does Hijrat Popal have? Because I thought that Hijrat was the licensee.
No, I mean, basically, Sajjad Popal is the licensee. He was also the original DPS.
Right.
And it was our argument at the original hearing that it would be no point in removing him as DPS, because ultimately the licensee is the boss. So I think that was on that basis that, well, he wasn't removed for whatever reason, and an application was put in to transfer the license to both the license and the DPS to Hijrat Popal, who is one of the brothers, who is also a suspect. And we objected on that basis, and that application was withdrawn either on the morning or the night before a separate hearing, just before, I think it was in October, November this time. There is a new application in for a second brother who is not a suspect in the matter, and it's to him that most of the control will, or it's been suggested, be transferred.
Okay.
As I say, this review was brought because that period of suspension didn't occur, and what was directed didn't occur. However, Mr. Dadds will explain from their point of view as to why that didn't happen.
Okay.
Sorry, I just wanted to ask you a supplementary question, really, about the conditions that were laid down at the last licensing hearing, some of which were about CCTV and what have you. Have you had any confirmation at all that those elements have been adhered to?
Well, those conditions have been put on the license. We made one request for CCTV, which was why the letter was submitted as one of the appendices. Apparently, that CCTV has been kept for us, but we weren't notified that was done. So that hasn't been tested as yet. But they are standard, up-to-date conditions, which was why they were added.
Okay.
We're also being told that the training with the council has taken place as well, which was another direction, but I can't comment on that. That would have to be for the council, the local authority, to comment on.
So we've got no evidence whether or not the CCTV conditions have been met, because you put in a request, but you haven't actually had the CCTV back from the request that you put in. No,
I mean, the CCTV, we were happy that it does work at the address, because that was what was seized initially, which started the investigation into that. So I'm not particularly concerned that CCTV doesn't work, just the one request that we've made for it, that hadn't been complied with.
Okay.
So before we go to Mr. Dadds, I think it would be helpful to hear from Mr. Tuitt.
Thank you very much, Chair. I think PC Hunwick's pretty much summed up everything that I would have had to say due to quite extensive discussions between myself, Mr. Dadds and PC Hunwick. We have reached this position which we are putting before you today, just having regard to the previous decision that's been made. So it really is just as a basis of those discussions that we've had that we've reached this point.
Okay, and maybe we'll come back to the question about the length of the suspension. I think Mr. Dadds, you're probably up now.
Thank you, Councillor Peters. Chair, can I just address you on 5 points very briefly? The first is that the matter of the criminal investigation is subject to sub judice, and I think we need to be careful on how that is spoken about, because this is a live broadcast. There's no determination of facts. The golden thread is you're innocent before proven guilty, and no one is suggesting where the truth lies, notwithstanding the council's decision to remove and the decision that we had before us to remove Mr. Popal. But that's not an admission or a statement by the council of an admission of guilt. I think we just need to be careful so that we don't, none of us commit a criminal offence of contempt of court.
So thank you very, very much for that. I'll just come back on that very briefly, if that's okay. I think we did have a conversation along these lines at the previous hearing, and I think it was made very clear that what we weren't doing is determining whether there was criminal culpability by any individual. I think that we were looking at the management of the premises, which is entirely appropriate for a licensing authority. Yes.
Thank you. I thought I ought to just clarify that on the public record as it might be reviewed this hearing. So going to the remaining 4 points in order, I'll just flag them up where I'm going. The first one is the position today. Second one is previous decision. 3 conditions for training. So the position today is that the responsible authority, the licensing authority, the Metropolitan Police and ourselves have agreed a position which is set out in the position statement. Of course, it's a matter for you and your colleague to make any decision that you think appropriate and proportionate based on the licensing objectives. But I'm conscious, and you will be too, is that you have regard to the submissions and the position of all parties here present, and the statutory guidance directs you to looking at the police licensing authority as the main sources of advice in relation to crime disorder. So obviously the parties are mindful and respectful of the committee, but also we've been working to discuss on what we believe is an appropriate way forward to promote the licensing objectives. I'm going to just jump actually to number 3 and 4 before I go to previous decision. In relation to conditions, I've been to the premises, and my colleagues here, Natasha Nunn and Jean Adams, have assisted in providing training. The conditions I'm satisfied are met, and training has been provided by this firm. An additional, obviously, refresher training will be done as time goes on because we now are engaged. In relation to the CCTV, I've asked my client whilst we were here just to confirm, but I believe a message was left with the police service, but I can't confirm whether that was a voice message or an email to say the CCTV is ready to collect. But it was downloaded and it is available, but I don't think it's been collected. Now, Where that lies, I don't know, but it is available. The CCTV does work, so that is available. In relation to the previous decision, I do not want to open hornet's nest, but I think I better go there a bit. The previous decision, its drafting is very poor. And on that basis, I don't think it reflected what you said, Councillor Peters, about a 3-month suspension. Whether that was your intention or not, but the decision of the licensing subcommittee, i.e. the decision by the licensing authority sent out on the 9th of July, did not say that. And that time has passed. That decision is now gone and finished and has, as I say, has passed. The decision actually, so that you are aware, it says this, if you haven't got it in front of you, I think you might have, the suspension of license up to 3 months or until a new DPS is appointed, an independent, which is ever sooner. Now, obviously, clearly, if they appointed a new DPS, there would be no suspension if they did it immediately. I think the issue being is that the condition before that was the current DPS is to be removed and a new one appointed after the liaison. So the words to be removed and after liaison does not mean that the DPS is removed. It should have just said if your intention was to remove the DPS. And by removing the DPS, they would not have been allowed to serve alcohol thereafter until a new one is appointed. So the issue is that the drafting of the decision is ambiguous and not clear. But in addition to that, it also added the words an independent designated premise supervisor to be appointed. And of course, a designated premises supervisor is just defined as that. So it's a statutory scheme. It just makes an application. I mean, you could advise that you would encourage that any new application do pre-application, but you can't, with the greatest respect, there can't be a set criteria of who can and who can't apply, because it's a statutory scheme. Anyone can apply if they've got a personal license. But in relation to this, we've had discussions about the new DPS as a person of good character, holds a DPS. The police would have difficulty, in my opinion, to raise the threshold of exceptional circumstances and object to that DPS. But what we've said is that, so I'll stop there for a moment. So we've had some discussions around that decision. And then the other issue arising is that because the way the decision is presented, it starts at the first page and moves over to the decision. And then for some reason, it inserts the details of the license and doesn't actually go straight to the closure, the point about the appeal and when it has effect. And then it moves on to all the license details again. And then at the end, the first paragraph again says the premises license shall run until it's suspended. So that's not normally put into a decision. And it says, I confirm any party agreed. That is not standard wording. And the parties, the premise license holder hasn't fully understood this letter. And with the greatest respect, it is not clear. It's been misunderstood by the police service, Graham Hopkins, the licensing agent, the council's licensing authority, and there's been a number of interpretations on it. And it is incumbent upon the council when it's making its decisions that they are clear and not open to that misinterpretation. As I say, the premise license holder, who is actually a company, not Sajid Popal, but obviously no criticism meant. The license holder is the company. Its director is Mr. Popal, who no longer is a director, has been removed. But in relation to this letter on appeal, it is not clear. And I would even go further to say that it doesn't set out that the decision was a Section 53 decision about interim steps and when it had effect. Lastly, I know that the premise license holder, or Mr. Pophow, tried to reach out and did reach out to Mike Smith, but I understand he is left and there were some difficulties in that communication too. But all that said and done, had they changed the DPS, there would be no need for a suspension because that was the decision. But that was previous. We are where we are today, and we've all taken a very pragmatic view in looking at what is the resolution that the police, the licensing authority, and the premise license holder would be satisfied with. And we are all satisfied. No one's overjoyed, but we are satisfied that the position statement that we have set out is a joint one that we can all agree to and with, and believe that that's all that's required to promote the licensing objectives. Now, I hope I've covered all the points, but if I can assist you, Councillor Peters, I'm happy to answer any questions you may have.
Thank you very much. So your point on the drafting of the decision at point 3, you're saying that the current, if the wording had been the current designated premises supervisor is to be removed, would have given effect to a immediate removal of the premises supervisor. Is that what you're saying? But because there is that additional wording, it doesn't have that effect.
No, it should have just said. It should have just said the current designated, or the current designated premise license is removed. That's it. It's not. You don't put to be removed. Is removed, and then the local authority to issue the license with that designated premise supervisor removed on the new license. So it would have been clear that there was no designated premise supervisor. But the license says to be removed. It doesn't say has been, it's not removed.
The decision, yeah.
Yeah,
So,
that's and this until and a new DPS to be appointed after liaison.
well, but that, I mean, the natural reading of that is that the designated premises supervisor is removed, and then there is no designated premises supervisor. So the DPS, until the new DPS is to be appointed, and that new DPS can't be appointed until after there is liaison with the licensing authority and the police.
Well, if that was the case, then you wouldn't need to suspend the license up to 3 months or until a new. You would just remove the DPS, and then once the new DPS is there, then they can open. That's the same effect. That's why it's not very good in its drafting. Because it's the statement is to be removed.
But there are independent conditions, and 4 was a suspension, and that's very clear to me that the license was suspended from 3 months from the date of that decision, and during that period there were sales of alcohol from the premises.
Well, it says actually the premise license to suspend the license up to 3 or until a new DPS is independent DPS, which is sooner, and that's repeated in the body of the decision. But there was confusion around when that started, and the premise license holder liaised with licensing to say, I want to put the new this person as the new licensee. So there was confusion about how you appoint the new designated premise supervisor. So the premise license holder thought that as long as they appoint a new person, there wouldn't be a suspension.
But they hadn't appointed a new person.
No, they hadn't. No, but they
There was suspension.
No, they liaised with the council to ask for someone to be appointed.
That was a precondition for appointing a new premises supervisor. Until there was a new premises supervisor, then there would be a suspension of the license. And the fact that it was only possible for the licensing subcommittee to suspend the license for up to 3 months was neither here nor there, right?
Well, it does say to suspend the license for a period up to 3 months or until a new independent DPS supervisor has been appointed, whichever is sooner. Obviously, he didn't understand how to go about getting an independent or making an application for a designated premises supervisor. He did reach out to Mike Smith and said, I want to appoint this person. And there was confusion of when the period of suspension was to start, because obviously the decision doesn't give you that the decision doesn't have effect. Well, if it's a section 53, we don't know whether it had effect immediately, because I don't know if the interim steps were changed, because it doesn't say in this decision. But obviously the decision doesn't have effect for 21 days. The police obviously thought it had a sooner effect. If it's 21 days from the 29th, it would be the 9th, it would be the 29th of July. So there was also confusion of when the suspension started. Now, obviously, I'm a lawyer. I would approach it slightly different, but I'm dealing with a lay client that's read this letter, that's trying to get some decision from the council. And then Mike Smith left, I believe, in August. So I think there has been confusion. Now, had it been me and I was advising, immediately I'd make an application within 21 days to immediately put a DPS, because the word independent has no validity. You just apply for a new DPS, and then if the police object, and then obviously you start again. But in essence, there wouldn't have been a period of suspension. Obviously, there's potentially could be argued a technical breach, but there wouldn't have been a suspension because you would have put a new one in immediately.
So I think the natural wording of this and the natural meaning of this must be that the suspension was intended to start immediately. In any case, to my mind, it's clear that there was a suspension and there was a sale of alcohol during the period of the suspension. And I think that the DPS and the licensee must have understood that to be the case. Councillor Root, did you have anything that you wanted to ask here or say?
Well, I suppose it's just a pretty obvious question, really, which was that if there was some confusion, did your client come back to the council officers to try to resolve exactly when the period of suspension was and what have you? I mean, was there any effort made to try and get some clarity from the council? And if not, why not?
Yes, I believe there was sought clarification from Mike Smith. And the reality of it is that had they had legal advice, which they didn't, I certainly would have said put an application immediately, because there'd be no suspension.
Well, there'd have to have been a suspension whilst the application was considered, wouldn't there?
No, because the decision doesn't have effect for 21 days.
Right, okay.
In law, so therefore there would never have been a period of suspension. It's unfortunately those two paragraphs. I accept, Councillor Peters, that 4 is a bit clearer than 3 is my interpretation. But it's a lay person reading it. But in context of the whole letter, from start to finish, it is not clear. And I see these decisions constantly, and I can tell you this is one of the worst I've ever seen. I went back and had a look at the last one of Hackney to see the decision on Unit 7, the wording of the appeal, just to see what that was like. And unfortunately, you didn't even put the wording that you can appeal within 21 days on that one. So clearly, these decision letters need to be looked at in a bit more detail, because it is important that they are worded correctly so lay people can understand them, because there is a standard statutory wording that should be put onto the decision about appealing in 21 days. The last decision that I looked at, not the one today, there was one previously that was made, I think, before Christmas. I dug that out because I knew that I had done that. And actually the appeal period of 21 days wasn't even on that letter.
So regardless of what you would have advised if you had been instructed, point 4 to me seems very clear that there was a 3-month suspension that started, whether it was 21 days after the decision had been issued, or immediately upon the decision being issued, or at some other point. And I don't see what other point that could be. There was a period of 3 months. There wasn't a designated premises supervisor that was appointed either after liaising with the police and licensing authority. So that period of 3 months, that suspension wasn't shorter than 3 months. It was 3 months, and there were sales of alcohol during that period. To me, that is patently clear.
Can I comment on that?
Yes.
Yep. You may have that view, and I'm not going to. The thing is, it's open. I'll accept that whether it was immediate or whether it was 21 days later, you and I reading it will say, well, that occurred. But because the way the whole decision is worded and when it was to start and the clarification trying to be sought, I think there is questions around whether this is clear enough. And the appeal point at the end that talks about it runs until suspension and the wording of the appeal, I think the client has, and I think it is right, that he would have a defence if prosecuted. Now, whether that no one's going to run that, because I think everyone is satisfied that the way forward today is to set out as the position statement, because I think it, had he taken advice, that's what I would have said, and there would have been no suspension. So we're trying to balance it with a discussion. We've been quite open with the police, the licensing authority, and we've discussed it, and we've come up with a period of suspension of 1 month, and that the other steps. I can confirm that there was no other matters arising before the incident you describe, and there's been no other material matters arising thereafter. So there's been no other matters arising in relation to any crime or disorder, notwithstanding the point that you make about if there's been sales or not.
Well, and the incident that we were talking about was a serious incident.
That's accepted, but I'm saying that before that there was no matters arising. There's that serious incident that there's been under investigation, but I'm just trying to reassure you, since then and now there's been no other matters.
Okay, and I think this was a point that we had considered at the previous review and taken the view that, notwithstanding that, the incident itself was of sufficient severity to warrant action being taken to protect the licensing objectives. So there was another point I was going to ask here. Is the suggestion that points 1 and 2 be included as license conditions?
Absolutely. Yeah.
And then 3 and 4 are just things that we would order. Is that correct?
Yes. Sometimes you can put them on the license, but you can it's the decision. But certainly 1 and 2 are lawful conditions that can be placed on the license. And you're right that if there's a transfer, then obviously the responsible authorities have an opportunity to comment upon that. But in any event, if there was a transfer, it still has the provision of exclusion of Sajjad Popal in any event.
Mm-hmm. Okay.
I've assisted in drafting that because that's and the police have had contributed. I understand these are fairly standard conditions when you're excluding.
Okay. Councillor Root, you're coming off mute now.
Yeah, I just wanted to ask, because when you were speaking initially, you seemed to imply that Sajjad Popal was no longer a director of the company Sherkan. Is that correct?
We've made the accountant yesterday, as I understand it, took steps to remove. So I think that the forms have been completed and been filed. So it might take a day or two on Companies House, but the process has started.
And are we allowed to know who the new director is going to be?
Yes, it's going to be the designated premise supervisor. Is it Barber?
Mm-hmm. And yeah. So Barber will become the sole director of of this company.
Yes, and the designated premise supervisor.
Okay.
He's a man of good character, a degree education, and so yeah, and I'm satisfied that he knows what he needs to do.
And what will happen to give effect to the second part of point 1?
Well, he can't have significant control or influence, so he can't be he can't have significant control.
So, I mean, my understanding of that is that that's about shareholdings predominantly.
Yes, right. Yeah, you can't have a majority shareholding, I understand.
So he will sell shares. He will be transferring certain shares.
I don't know what the position is on the financial side, on monetary side, but he cannot have a controlling share.
But nothing has been done to give effect to that part of.
Well, the accountants, I understand the accountants are doing that. That was inserted this afternoon. So unfortunately, I've been in hearings all day, so I have not done anything further, but we'll make sure that the steps are taken to ensure that that is done before the 21 days.
Okay.
But in relation to the suspension, even though your decision doesn't have effect for 21 days, we have all agreed it's straightforward and simple that it's the whole of February that there's no alcohol sold. And so that it's absolutely clear all the alcohol will be removed from display and put into the store.
But if the decision doesn't take effect for 21 days, does your agreement mean that this suspension will be enforceable before the period of 21 days expires?
Yes, we will, in effect, we will be removing off from the 1st to the 28th, and we will not be selling. So
what happens if you do sell during the first half of February?
You could. So from a technical point of view, from a legal point of view, your decision does not have effect for 21 days.
Yeah.
However, if I'd like to say from a licensing point of view, if this is and we are agreeing to this, if a sale takes place between that time and there is evidence of a sale in that time, the police will come back and call a review, and I can probably hesitate a guess that this license would be revoked. So there is a sanction. It's not there is.
Yeah. Could I hear from? And I suspect you would come back and tell us that actually there was no breach of any of the license at that point, Mr. PC Hunwick.
No, I would actually. I think I would be professionally embarrassed, and I couldn't represent them. So,
okay.
With greatest respect, you're not getting double standards from me.
Okay, PC Hunwick, could you just talk to us about this point yourself? Sure, and specifically on when the suspension should begin. And
no, you want about the fresh suspension, Chair?
Well, the fresh suspension. If we were to impose a suspension of 1 month, should that start on the 1st of February? And so there would be an element of trust that, perhaps not an element of trust, but it would mean that the enforcement of that period of suspension would be by way of you coming back for another review rather than being able to enforce that as a breach of the license.
I would be. I mean, like I say, I'd be comfortable either way because, I mean, just to explain, obviously we went for revocation in the first hearing. I'm assuming that you were satisfied if what you directed the first time round had occurred, that the business would still be allowed to feed the remainder of the family, which is why we've gone along the lines that we have this time. With regards to the suspension period, we would be quite happy if you wanted it to start in 21 days, so it was legally binding, so that any sales, unauthorised sales, could be prosecuted both from a criminal point of view, and we could obviously go for a review as well. I don't think it really makes an awful lot of difference from a financial point of view. Obviously, there will be that financial penalty for the 4-week period whenever it starts. So I'll be quite happy to leave that to yourselves to decide, Chair.
Because I'm thinking about the enforceability, and sorry, Mr. Dowds, I will come back to you in a second. I'd just like to hear from PC Hunwick and probably Mr. Tuitt as well. I'm just thinking about enforceability. It creates an additional hurdle for you, doesn't it, to have to come back you have more options in enforcing this license if there is both an agreed period of suspension and an enforceable.
Yeah, it would be a double whammy because they'd be able to be prosecuted through the court, so we'd be able to hit them further through the pocket. And obviously, it still doesn't preclude us from bringing the matter back to yourselves, because I would suggest one sale and they're out. If you're happy to go along the lines of what we've provisionally agreed, because our concern is that the individuals that may be responsible for the crime are removed from the scene, and we are happy that this does that. If you're not of a mind to revoke, which you weren't. So I think from this point of view that if whoever was involved with this now, and obviously with Mr. Dad's on board, there should be no excuse that they fully understand what any decision means, whatever decision you make would mean. And therefore, if they were to sell even once, I think we would be quite within our rights to bring this before you again.
Yeah. And can I just hear from Mr. Tewitt as well on this specific point about when the period of suspension, when it would be best for the period of suspension to begin?
Well, I'm just looking, just reminding myself of what the Act says. So, Section 52, determination of application for review, paragraph 11, and it's a determination under this section. So, the section on reviews does not have an effect until the end of the period given for appealing against the decision. So what is being discussed is correct. The period wouldn't actually start until until that 21-day period is up. But as Mr. Des is offering to start it early, effectively, and for the whole of February, so it's a degree of trust on our part.
Could I just interrupt, Mr. Chairman, and just look? I think one has to be practical about it, because if we, for example, sell in February, technically we're allowed to, but then when it does bite, then you'll have to have it then. So in either way, it's never going to be avoided. But what I'm trying to do is, one, at the moment, some decisions are taking longer to come out of Hackney. Two is to give it a start date and an end date, so it's very clear, so there's no misunderstanding. And I just thought February is quite clear, gives them a few days for Sunday to clear all the alcohol. The whole of February, that's it. I mean, technically, if the decision doesn't come out for 5 days, right, until the end of the month, then you've got 21 days. It wouldn't bite then until around about the 21st of February. And so, we would have done 3 weeks of closure. If not, if we don't, it would start from then the 21st for a whole month. So unless we appealed, which obviously we don't intend to appeal, we agree with these conditions. So I think, yes, your word about trust, I think actually that's a fair word, that trust, but it's clear. Everyone knows what we need to do. And if we don't comply up to the 21st of February, as an example, then the police will be going along saying, there's your date, that's when it starts, that's when it ends. If you sell, you'll be committing a criminal offence, but also will be coming back for your licence. So does that assist?
It doesn't. It doesn't. So on the question of trust, I think that the trust has been worn out here. I do think that is very clear that there was a 3-month suspension, and it appears that there was selling during that period. So I don't think it would be appropriate for us to undermine the ability of the police and the licensing authority to enforce any suspension. I think it would be most appropriate, and Councillor Root may agree, that any suspension starts when a suspension ordered by this subcommittee could legally start.
Okay, and could I ask then, if that is your wish, and I'm happy to accept that, could you potentially direct officers to make sure in the decision letter, when it does go out, to give it a date of having effect for the start and the finish, so there's no misunderstanding? All I'm trying to do with February wasn't anything else. It was just trying to make clear for everyone.
Yeah.
So But if a letter comes out and it's clear for everyone, I will get 21 days to which to advise the client to say when the start is and when it finishes. So I'm here to help my client comply, promote the licensing objective. So that's my intention. So I'm here to help.
Thank you for that. Councillor Root, sorry, you came off mute, so I think you might have been about to say something.
No, I was just about to reiterate what you're saying, really. I mean, it does seem to me that if we're going to have a suspension of any sort, we've got to have a way of enforcing it. And, you know, whilst I appreciate that Mr. Dadds might find himself professionally embarrassed to come back and argue that actually the suspension doesn't legally come into force for 21 days, etc., etc., you know, there may well be other professionals who haven't been involved in the case who would be prepared to argue that. So I personally would much prefer to have it starting from when it can be enforced, actually, because otherwise I think we're tying one arm behind our backs.
Okay, thank you very much for that. So I think that what we're saying, and Mr. Dadds, correct me if I'm misinterpreting what you're saying, is that you'll be happy with the position statement as it stands, but that in relation to points 3 and 4, there is a 4-week suspension starting at a date that is stipulated in any decision that we issue.
Yes, the dates will be automatic, because if the decision comes out in 5 days' time, the date of the email to us or the decision, it'll be 21 days from that date, so we can calculate it.
So, I mean, that's when it can come into effect, right? So
when it does come into effect, yeah.
I mean, you've already argued in front of us that a suspension that we ordered last time didn't come into effect, perhaps never came into effect, right? So I think we will need to make sure that we include sufficiently specific wording so that there is absolutely no ambiguity in the future, or no ambiguity that could be argued. Okay. So I think if we go back to the meeting procedure, we're probably all the way through to step 8, closing remarks. If there are any closing remarks that I don't know what order we do these in, but PC Hunwick, if you have any closing remarks, then feel free to.
No, Chair. I think we've basically explored all the avenues we've got. Obviously, everything's laid before you. The parties have, in advance have agreed that position statement, but obviously it's put before yourselves to make the ultimate decision, and that's where we're at with it.
Okay, Stuart.
Likewise, Chair. Position that was agreed with amongst ourselves, but ultimately put before yourselves to make that decision.
Okay, thank you very much, Mr. Dadds.
Likewise, Mr. Chair, it is a position we've all agreed, but it's ultimately your decision. But I do say that the statutory guidance does encourage the parties to have that discourse, and that I'd ask you to adopt the position, albeit that the 4-week suspension comes into effect once the decision has effect, which is either 21 days after it is given, or until the period of period of appeal, and the appeal is determined. So on that basis, I have no further comment to make.
Okay. Councillor Root, did you need any clarification on anything that you've heard?
I suppose I just want to be absolutely clear about this business about the sale of alcohol in September, August, etc., etc. Is your case, Mr. Dadds, that the licensee wasn't clear that he was not supposed to be selling alcohol in that period, and that's why he was selling alcohol? Is that what you're saying?
In essence, yes. But it's not as simple as that, because in fact, it depends on where you see that there obviously is a period of time where that period of time is subject to some debate, but certainly I would, if I was to give an opinion, I would be saying that the decision would have had the effect on, I think it was the 17th of June, that the suspension should have been for the June, the July, August, September to the 17th, if that is what was intended, but it's not been written clearly. So therefore the 26th of September closure didn't have effect, and the DPS closure for November wouldn't have had effect, because the condition is that there's always been a DPS, because the DPS has never been removed. It's to be removed. But I think because of the wording, because of the sort of clarification, there has been no suspension up to now. And we want to take that opportunity to suspend it now so that it is there. I mean, as I said to you, had I been advising at the time, there would have been no suspension at all, because I would have advised that the new DPS be put in within 21 days. So, but in any event, I wasn't there. Advice, the notice is not clear. Graham Hopkins wasn't there to give advice because he's an agent, so he can't give advice on appeals, because it's a restrictive practice or service that you can't give unless you're a solicitor or you have rights to give that advice. And I think Mike Smith also left, and we were in a pandemic. So I think there were a number of it was a perfect storm, but I don't believe it was intentional. And I think by doing this, what we're doing today is trying to get that resolved and to make sure the sanction is put in place.
I guess what I'm thinking, when I look at point 4, to suspend the license for a period of up to 3 months, if I were a layperson who hadn't consulted a lawyer and didn't know about the 21 days, I think I would probably assume that was starting from the day of the hearing, which was in June, I think, wasn't it?
Yeah,
So,
I did ask them that, and I'll be candid with you, I did ask that, why didn't you interpret it this way? And I've done that to try to understand. And what was said back is that it was the position that says or until you have an independent, and the condition above says you have to liaise about that appointment. So I think there was misunderstanding of that, because you start to engage with the council about having a new DPS. If you put a new DPS in, then there wouldn't be a suspension, which is you have to make the application. And I think that's the misunderstanding. They're thinking, oh, well, we'll agree to that and we'll start the process by speaking to the Mike Smith about it. And that's not sufficient.
yeah.
It's not ideal. I know it's not ideal, but I mean, it's dealing with lay clients, people that English is not the first language, and a decision letter that could be clearer, and the client a premise license holder taking maybe a bit more proactive steps and getting some advice. It is a bit of a mess all round, I say, and I'm trying to cut through it and to come to a position all agreed, which I'm pleased that David Chewett, being very professional, has agreed a position, same as Neil Hunwick. We've all had that discussion. We've all discussed it very frankly about how it could have been or should have been interpreted. But that's you.
That's all. Thanks, Chair.
Okay, thank you very much. Councillor Root, do we need to retire to consider our decision?
I think we probably do.
Would you be happy to grant the license on the basis of the we need to retire? Yeah.
I'd like to retire, I think, yeah.
I'm having some connection issues. In which case we will do.
So are we, Chair, just to clarify, we are now ending the meeting. And with the exception of yourself, Councillor Root, the legal officer, we will sort of come to a decision, and then obviously submit a written decision after that.
Well, yeah, I mean, I guess
To be
that
clear.
Mr. Dad, so we don't come back again as
Correct.
we
Yeah,
would.
that's what. Yes, that's what I was trying to clarify. Thank you, Councillor.
I mean, you know, personally, for Mr. Dad's sake and the sake of his clients, it seems to me that we could have an adjournment, let's say half an hour, and we could reconvene at 8:30, and at that point, probably be able to give Mr. Dad's an answer,
Yes.
and then
That would be helpful if you would allow that.
is that something that's possible, Mr. Sykes?
I'd have to consult. I would like to consult with the legal officer present, just to be clear.
I don't see that there's a problem with that. I think what we may have to do is ask the people, everyone else to leave and rejoin the same link at 8:30. Would that be a problem? I don't think the link is a problem, is it, Mario? They can rejoin the same link. Mario? Anyway, I think that's the same link.
He says yes, no problem.
Yeah, it should work, is what I'm saying. So that would be fine if that helps members.
On that point, then, asking the Mario, would this be no different than if we say we took a 10-minute break? Because I'm very conscious. I don't want to sort of cause any technical problems if I close the meeting down, which I don't think is probably wise.
We'll have to, not stream. Yeah. He has to. Yeah, it would have to be. Yeah, like a break. Yes.
So obviously there'll be. So I'm. Apologies that we're getting to sort of the territory of IT issues now. I'll try and be as brief as I can. Mario, then there'll be a sort of up on the YouTube, there'll be a screen that will come up to say that we're kind of technically in an adjournment and a break. Brilliant. Thank you, Mario. Thank you for that. Thank you.
Yeah, I'll leave now and I'll return at 8:30.
Okay.
Thank you.
Thank you.
Thank you.
back. Okay, welcome back. We've had a brief adjournment for this licensing subcommittee C meeting. So we are now going to go to the decision.
Yes, so we do have a decision. Thank you very much for everyone for bearing with us there. And our decision is that the position statement put forward, put to us by the licensee should be accepted in respect to the first two conditions, namely to permanently remove Sajad Popal as director of the company Serkan Limited, and to permanently remove him as a person with significant control or influence over that company, and that he will not undertake any activities related to licensable activities or management of the business, and shall be excluded from those premises at 478 Kingsland Road. In respect to the final two conditions or points in that position statement, it is our view that a 4-week suspension is not appropriate, and that it would be appropriate that the license be suspended for 3 months, starting from 21 days from receipt of the written notice of this decision, and that all alcohol should be removed from display on the premises during that suspension. The reasons for our concern Mr. Sajad Popal as in his involvement in the business, in respect of the seriousness of the original incident that gave rise to the original review, but also the failed test purchases made during a period during which it was clear that the license was suspended when Mr. Sajad Popal was designated premises supervisor. So because of those matters, the licensing subcommittee was satisfied that Mr. Popal's continued involvement with the business and with the licensee would be likely to undermine the licensing objectives. We were satisfied and are satisfied that Mr. Popal's, Sajad Popal's removal satisfies our concerns about his involvement with the business and whether the licensee would be likely to undermine the licensing objectives, such that there would be no need to revoke the license in its entirety. We considered that a 1-month suspension would not be appropriate because of the original 3-month suspension that was imposed by last year's licensing subcommittee, and that was not complied with, and it would be inappropriate to impose a 1-month suspension following a failure to comply with a 3-month suspension. And finally, that a 3-month suspension would give the licensee an opportunity to comply with the conditions around the removal of Mr. Sajad Popal, and to demonstrate that those conditions had been complied with. The decision will be sent to the licensee shortly. Thank you very much, everyone. Mr. Dodds, do you need some clarification on anything I said?
No, thank you very much, members, for your time.
Thank you. And with that, I think I'll close the meeting. Thank you, everyone, for coming.
Thank you very much.
Thank you, everybody, for participating. Thank you, Council.